pass.
Thank you.
Hero of the hour.
Are you all set, Jen? Good afternoon and welcome to the Senate Judiciary Committee meeting. Start off by all we are a little behind our time, but we did some technical difficulties. We are now live streaming and there was an issue with the microphones. Oh. Good afternoon, the Senate Judiciary Committee meeting of January 11th, 2022. I apologize for the late start. We are now live streaming and we had some technical difficulties. So again, guys, we're going to start today by opening the public hearing on Senate Bill 293 and recognize the Prime Senator Gray. And I'd like to apologize, Senator Gray, for the lateness and to thank him for being here.
Thank you, Madam Chairman. Members of the committee, I represent Senate District 6, which starts on Alton, goes down Route 11 to Rochester. I'm here to introduce Senate Bill 293. It becomes an old friend, I think, of your committee. It's been here before with different numbers. Relative penalties for violation. The history of this bill is that the police chief in in a conversation with the other police chiefs in Stratford County talked about the difference in recording the voice of someone and that being a felony and someone recording a video of a person in some state of dress, and that was only a misdemeanor. That was brought to me from the chief, now retired chief in Rochester, endorsed by the county attorney, Mr. Velarde. This bill that you see is, I guess, the third time before your committee. The first time it was ITL, the second time it was passed by your committee, but it was in an omnibus bill, and some things happened in omnibus bills in a different chamber that I want to talk about. So it is back here. There was a case recently in Dover of our, I think it was Dover, an individual who had prior convictions. The individual actually got in bed with the occupant. And this was not their first offense. Had this bill been passed before, would it or would it not made a difference? We believe that it could make a difference, and we are still a question about when the second offense occurs, whether it's after conviction, and the bill does state that it is after a previous conviction. So if there are two incidents, somebody with the second offense, a portion of this would not happen until some other occurrence. So with that, I would be pleased to answer any questions, and I may be able to get you back on time. So.
Thank you very much, Senator. Any question in the committee? Seeing none, thank you very much for your testimony this afternoon.
Thank you, Madam Chair.
Are there any other members of the public who would like to speak to Senate Bill 293 FN? Seeing none, I'm going to go ahead and close the public hearing.
Thank you, Senator. We need to be back on time.
Yeah.
is the second degree felony? Yeah, what is it?
Class A,
B, what do you go away from?
up to 3.5 to 7.
No, I just like the. It says any person who requests the restraint under the section commits the second or subsequent restraint. So are you saying that you don't I'm gonna circle that. Yeah, that's easy. Now we're just gonna wait for that one.
You would never first offense.
Oh, he's there. Sure.
Sorry.
There, get him.
That's where we're going to be back this Wednesday.
Absolutely.
We didn't have public hearings in the spring of 2020. And then last year.
Sir,
See you, sir.
how's it going for you? Richie, how are you?
We're going to go ahead and open the public hearing on Senate Bill 295 FN. Guys, the prime sponsor, Senator D'Alessandro. Good afternoon, Senator.
Thank you, Madam Chair, and distinguished members of the committee, and I know to have a group here. Senator French is one of the real relics of another age. Welcome. Great to see you. Wonderful to see you, Senator Khan. Wonderful to see you. It's Senator Carson, always great to the school yesterday. And it looks terrific. Yeah, it looks terrific. First of all, many thanks for allowing me to be before you on this piece of legislation. This is a reboot of Senate Bill 439 as amended by the Senate from the 2020 session. Senate Bill 4 tabled in the House without ever having a hearing due to the suspension of legislative activity as a result of the COVID-19 pandemic. I'd like to request one change in the third paragraph on line 13. It says a Class B misdemeanor. That was a misdrafting. It should remain. It's on line 13. So thank you very much. If you could attend to that, that would be great. I've brought this bill back this year at the request of the constituent who asked me to speak, Sergeant Nick Gregorius of the Manchester Police Department, Madam Chair, but he's come down with COVID, and as a result of that will not be able to attend. The bill increases the penalties for certain non-consensual violations of privacy. The bill was requested by David Manchester, who went into a series of situations where people were taking pictures of individuals in the privacy of private places that were sexual in nature. This is a violation of privacy. It is non-consensual photographing and videoing. The offense is currently a Class A misdemeanor. This bill makes it a felony to violate section small a. There is no option for a felony analysis of the victim prior to conviction of circumstances. The detective believes that RSA 644:9 Cole and I, it should be elevated to a felony rather than a misdemeanor. Under this legislation, 1B and 1C would remain. It was brought before the Senate committee last term. You did make a modification. The modification is included in the legislation that you have before you. As I mentioned, the police sergeant is tied up with COVID. He was not here, and the one change was on line 13. A Class B misdemeanor be changed or retained as a Class A misdemeanor. I thank you very much for your attention and would appreciate your support on this piece of legislation. If there's any questions I can answer, I'd be happy to do that. Thank you, Madam Chair.
Senator, are there any questions from the committee? Senator D'Alessandro, I'm sorry. No, Senator Khan, go ahead, ask your question.
Senator, I disagree with where you're heading on this. What I wonder is if you've also got.
I'm in agreement with where you want to go with this legislation. What I just want to see if you've given any thought. We've got section 644(9)A about the sexual images, and I believe that there's something in here that any person who violates this would be guilty of a Class B felony. No, that's not the one. I mean, those should be synced up, right? That's your intent, is that if somebody, one, commits the act, and two, disseminates a private sexual image,
Right.
that the penalties ought to be the same.
Yes.
Yeah. And I just wanted to clarify that. I want to go through the 9 and just see that as we elevate penalties in this section, that we are comparably elevating them in the other section.
Thank you, Senator Khan. We think alike because I wrote a question asked, does this conflict with the language that we passed a few years ago dealing with revenge pornography? And we want to make sure that we link them up and that they reflect each other. The other question that I had is that we're talking about. Are you talking about a situation where they meet and they decide that they're going to engage in a physical relationship and they go over to someone's house, but they're unaware that the person has actually set up some sort of recording device in the bedroom that will record their intimate acts, and then either they keep it for themselves or they decide that they're going to sell it or put it out on the internet? Are you talking about those types of situations?
I think they could be included in this, but the situations that were specifically we were referring to is situations that took place where individuals were using the at the schools and creating this activity, and that's what he witnessed, and as a result of that, asked that these penalties be enhanced. And it's a violation of privacy. It's a non-consensual photographing and viewing, and that's what he was witnessing. And I think the application you mentioned is also falls in the same vein, I believe.
Okay, thank you very much.
Well, thank you, Madam Chair.
Senator.
Thank you, Madam Chair. Thank you, Senator. Line 14.
Line 14.
It's outside private place. Would that be on the streets, or do you know what's the intention for that?
That's existing. That's the existing statute. Yeah, it exists now.
Okay.
Yeah.
Okay, thanks.
You're welcome.
Are there any further questions, committee? Okay. Seeing no more time this afternoon,
Thank
Senator.
you, Madam Chair, very much. we'll keep.
Are there any other member of the public who would like to speak to Senate Bill 295 FN? Seeing none, it's a public hearing on Senate Bill 295 FN. The committee will be in recess for 5 minutes. The committee will come out of recess, and we're going to open Bill 302 FN, and Senator Gannon is going to introduce the bill. Senator Birdsall is not able to be here this afternoon. Senator Gannon.
Thank you, Mayor. I had a lot of fun last night because I hadn't really read the bill up to the level that I should have, because I was going to learn here. So I got to revisit some things I haven't done in a long time, due process clause. And the main thing I got out of the bill is that I want people to have freedom of association and the chilling effect it can have if we don't allow people to donate anonymously. So, but I'm going to stick with Senator Birdsall's testimony because she told me to, and fair in a nice way. The reason for the Personal Privacy Protection Act is simple. It ensures individual donors to non-private organizations who wish to maintain their privacy have the right to do so. Donors may wish to remain anonymous and charitable for many reasons when they're charitable. Beliefs, a desire to avoid unwanted solicitation, or an inclination to keep the spotlight off themselves instead of shining on the good work performed by the charities they support. More recently, donors may want to remain anonymous for fear of reprisals or harassments for giving to certain nonprofits. I didn't realize that this went way back. The fear of harassment went back to 1956. There was a Supreme Court case in Alabama. The Attorney General had decided, I'm not going to just, the Alabama Attorney General wanted an organizations to hand over their list of the names and supporters to state officials. They were doing it for nefarious reasons. The NAACP refused to comply with the demands out of fear that they would not only, it would chill charitable giving to the organization and also open up their members to harassment and intimidation. The Supreme Court unanimously decided under this 1956 decision that the free association of its members, that freedom of association to work with organizations dedicated to the advancement of the beliefs of the ideas is an inseparable part of the Due Process Clause of the 14th Amendment, and the constitutional rights of the petitioners superseded the state's interest in obtaining the records. Unfortunately, for 66 years, this type law has been tested in and out, but time and time again, the Supreme Court has always went on the side of the donor's privacy. Most recently in the case, there was a California case against their Attorney General against the Americans for Prosperity. It was called Americans for Prosperity versus Bonta. And again, the Supreme Court decided in favor of the plaintiffs to protect the privacy of the donors and the organizations. Let me just give you their quick two-sentence summary. In the decision, the gravity of the privacy concerns in this context is further underscored by the filings of hundreds of organizations as amici curiae, or friends of the court, in support of the petitioners. Far from representing uniquely sensitive causes, these organizations span the ideological spectrum and indeed the full range of human endeavors, from the American Civil Liberties Union to the Legal Defense Fund, the Council of Islamic Relations, Zionist organizations. Donor privacy really matters, especially right now. People have a fear of the government, a fear of a lot of things, and they're sometimes founded, sometimes not founded. But privacy is an essential. The Supreme Court has found it time and time again. We want to ensure that New Hampshire will not find itself in the same situation that California did last year, which resulted in the end of a 7-year lawsuit, expensive to all parties, unsuccessful again, as the last 6 years of this type of ruling have been. So if the committee is agreeable, we would ask you to hold exacting this particular bill to order for an amendment to be worked on that addresses issues recently brought forth by the charitable trust. Thank you, Madam Chair. I can entertain 8 questions, and there are lot more the due process clause and how it applies.
Thank you very much for your testimony, Senator Cannon. Are there any questions? Okay, seeing none. Oh, Senator Khan?
Senator, either private sharing. This is
Of their own free will.
sorry.
Such as, like, we'll say the NAACP sharing this.
Yes.
I guess they could if they wanted to, but they will get.
If organization share of the other.
I would make that in a different context. Do their members have privacy interest? That's a different question. I think other people can testify better to that, but yeah, to me, offhand, that's a totally separate question from the government's demandation. A different question, I believe, than this question.
Yes.
But a good question.
And we're not addressing that, so, yeah.
You're here. Did you wish to testify on this?
Thank you. I had a plan to testify. Thank you.
Just so, the only reason this is really the first time that we've been back here in session. And Representative Lynn is a member of the House, and the courtesy protocol that we have is usually the senator and then the representative. I wasn't sure if Representative Lynn knew that he needed to sign up. So I wanted to make sure that he had the opportunity to speak.
Thank you very much.
Yeah, and he is listed as a co-sponsor of the bill. Yeah.
The chair is going to call Tom Donovan.
Thank you, Your Honor. And I'd like Assistant Director of Charitable Trust to join me to save time. Diane Quinlan.
Diane Quinlan. Okay. The only thing that I would ask, if you're both testify, that when you first testify, that you let us know who you are, so that way Jenny will be able to. Thank you.
Good afternoon, Senators. Tom Donovan, Director of Charitable Trusts in the Attorney General's Office. SB 302 is well-intentioned to address donor privacy, and we respect donor privacy in the trust unit. As you know, charitable trust, our responsibility is to exercise the Attorney General's common law and statutory oversight responsibility over the charitable organizations that do important work in our state every day. We think that this legislation is a reaction to the decision by the U.S. Supreme Court that came out this past year, Americans for Prosperity versus Bonta. That involved a California requirement that large donor information about large donors be provided routinely to the Charities Bureau in California as part of their annual reports. Sometimes it's referred to as Schedule B information. Provided to the IRS confidentially, but California wanted it as well. Was noted before, the Supreme Court sided with the donors in that case. California lost. So that information may not be collected by attorney generals around the country. And New Hampshire never has asked for donor information. We don't need it, and in that context for it. So I'm going to ask Diane Quinlan now to go over some specific concerns we have, consequences that would result from this legislation, and we have, and addresses those issues.
Thank you. I'm Diane Quinn. I'm the Director of Trust. The concern that we have proposed bill is that it would prohibit the charitable trust unit from obtaining the names of members and volunteer donors without having to first file a lawsuit, something that would be very and the board members, particularly when such expense can be avoided. So why would we need this information? First of all, it's remember that most members of boards of directors of charitable organizations are volunteers. And we believe it's in the public's interest that charities be required to disclose to the charitable trust unit those who govern the charity, and that they register, that they include that as part of their registration process and requirement. Why do we need this information? We often contact members of boards of directors directly rather than through the sometimes it's because the matter that we are calling the charitable organization about involves the executive director. Other times we discover that members of the boards of directors are actually not members of the directors because until we contacted them. It's also important that law requires that charitable not-for-profit corporations have at least 5 members who are unrelated by blood or marriage. When we receive a list of board members, we often can determine whether or not they have fulfilled the requirement. And if they haven't, we contact the charity to let them know that they need to elect new board members or how they are able to comply with New Hampshire law. We need to know the names of the directors often to determine whether or not a conflict of interest exists, and that's part of our responsibility to oversee pecuniary benefit transfers of directors. We also think it's important in the policy for members of the public to know who the governing board members are. Now, we do not think, however, that it's appropriate to publicly disclose their personal addresses and their personal contact information. But the names, the people who are governing this public charity, is public to know. It's also important to remember that we're not the only agency that collects this information. The New Hampshire Secretary of State's office collects names of the board members for charitable nonprofit corporations. Every year, charitable nonprofit corporations disclose the names of their board members, and they published on the Secretary of State's website. Or donor information. We rarely request member information. And typically, when you think of member information, you think about members of the NCAACP or something like that. Look at corporate members. So healthcare organizations have sole corporate members, and it's important for us to understand who they have reserved powers. And in our role in reviewing hospital transactions and healthcare transactions, it's important for us to understand who the members are. With respect to information, as Tom mentioned, we typically do not ask for donor information. We ask for on a routine basis at all. However, there are occasions when donor information is particularly helpful to us. For example, that some charities have been set up to support a for-profit enterprise of one of the directors. Donor information has been helpful for us in determining whether the donations were actually made for services rendered by the for-profit and not-for-profit to for-profit, funneled through the for-profit to the for-profit. Donors could be victims of acts by a charity. It's helpful to get that donor information so that we can help provide to the donors and determine how much restitution is owed. These can overinflate the value of gifts in kind on its public reports in order to make their overall donation to look more favorable. And we've been able to discover this by understanding are their 990s, and we can figure out that the amounts are not comparable. That's important because it's an unfair and deceptive act of practice when charities try to make the value of their revenue to make their administrative costs look small in comparison. Sometimes donations are to get a more significant economic transaction. And that might be where a real estate developer makes a donation to a charity in exchange for favorable treatment with respect to a real estate transaction. While this allows us to file a lawsuit to obtain this information so long as are met, it would be expensive to do that for charities and board members. Currently, the unit can obtain this information when it needs it, and without the expense of filing a lawsuit. Oftentimes, after getting this information, we are able to resolve a matter with a board of directors and a charity, either through a settlement or an assurance of discontinuance, which is short of filing a lawsuit. Sometimes it's as simple as us telling the charity they're required to do certain things in order to become into compliance with New Hampshire law. But we can't get to that point without some of this information. So Tom, our role really is to regulate charities, to oversee. A very important part of our role is also to educate charities. We'd much rather be in a position to be able to work with boards of directors to bring them into compliance than filing lawsuits against them. So, Tom?
If there are questions, we can.
Thank you very much for your testimony. Are there questions? Senator Gannon?
You can just help me with the law. Why, and even going back to the 56 case I had mentioned, they said the donor information was private. Why doesn't that stop you from doing it? Why aren't you following that precedent of the Supreme Court? Haven't they already spoken on this matter? As far as the donor part, I'm not talking about the board of director parts, just the donor.
A good question, Senator. Both of those cases were looking for wholesale lists of donors. We don't look for wholesale lists of donors. We think that is inappropriate. We believe that the NAACP case and the Bonta case both stand for that proposition. When we look for donors, it's because there is a specific issue, as Diane Quinlan mentioned, and it's not, in most cases, all donors. It would be the ones that are affected by a particular transaction or series of transactions that we're worried about.
Follow up?
Yes.
Just how often would this come up, do you think? Have you said that you could sue them right now to get the information? If you had it rose to a level high enough, you could get the information. Is this something that's coming up or would come up or would have come up recently?
So we, Tom Donovan again, Senator. So a few times a year, perhaps. Diane Quinlan just won a case involving a sham breast cancer charity, Fab Family Fund. And in that case, part of the remedy she got was restitution for donors. And there was particularly one donor who we contacted and was very unhappy that he had donated for this. And so we needed that information to have that contact with the donor. And hopefully that donor will get the money back.
Right.
Thank you.
Are there further questions from the committee? Thank you for, okay. Senator Khan.
Thank you, Madam Chair. Is the department suggesting an amendment or just opposition to the bill?
So we don't think the bill is needed. However, we're always willing to talk. We think that, for instance, things protecting addresses and telephone numbers is appropriate, so that we do think it's already an exemption to the right to know law. And so we don't disclose it, but that sort of protection is certainly reasonable, and so we could work on something like that.
That would allow for you to receive that information.
But not disclose. Right, not to disclose it. We think we need to receive it because we need to be able to contact them, but we don't want disgruntled people being able to call up a director of a charity, for instance, and saying, why are you doing this? Why? And so we don't now, but having further protection and don't deal with that.
Questions? How does this work with profits who are hired by companies? We do that quite often.
So on that, I would hope that I can't see a need. For instance, if DHHS wanted to hire a mental health center to do some work, I don't see that they would need to look at a donor list. I do believe they may require the names of the directors, just like we do.
Mm-hmm. Okay, thank you. My question is for Layman. Could you please furnish the committee with a copy of the Case for Prosperity Foundation versus Bonta? Thank you very much. Are there any further questions?
Thank you, Madam Chair. You look at a lot of audits, no doubt. Are donor names ever disclosed in audit statements?
I'm sorry, I didn't hear.
Donor
Are
names.
donor names disclosed in audit statements?
I don't recall seeing donor names unless they're no, I don't recall seeing them in the audit statement, on the audit reports.
Are there any further questions? Okay, seeing none, thank you very much for your testimony.
Thank you.
Next, we're going to call Greg Moore.
Thank you, Madam Chair, members of the committee. For the record, my name is Greg Moore. I am the State Director with Americans for Prosperity, as well as the State Director with Americans for Prosperity Foundation. And for lying that the case is actually Americans for Prosperity Foundation, not Americans for Prosperity. Two different organizations. Americans for Prosperity Foundation is a 501c3, does not advocacy, it focuses exclusively on research and education. Americans for Prosperity, the 501c, is in advocacy quite a bit, as well as grassroots organizing. So we're not involved in the development of this legislation. Certainly, when your design is most relevant, it certainly gets your attention. So that's the reason why we're here today. We're supportive of Senate Bill 302. Talk a bit about the history, a very short version. In 2014, the Department of Justice in California sought to get a list of American Prosperity Foundation's donors. Obviously, we felt that there was a compelling amount of case law that supported not providing that, and we litigated that out as prior speakers for the next 7 years. So this case really isn't about us. I don't think any Attorney General in right mind would come back to that well again, knowing that we have the resource and gumption to take you to the Supreme Court and beat you. So I suspect it unlikely that this in fact does. However, saying that, even though I am the state director for a major national nonprofit, I also sit on the board of several other nonprofits, and it's frankly a concern for them, organizations that don't have the resources to get their rights preserved. I want to talk a little bit about the case. It ended up getting over 300 amici briefs filed, and amici briefs range on the Gun Owners of America, the Heritage, and the Reason Foundation, to, on the left, the ACLU, the Human Rights Campaign, and PBS. So effectively everything between, from humane societies to college and city, and legitimately the full gamut of any type of nonprofit entity came and wrote amici briefs in our case. As far as the legislation, the outcome, the Bonta case, that was a clear and convincing reaffirmation of the importance of free expression protected in the First Amendment. And we think that the case is pretty clear. So I think that when counsel shares that ruling with you, I think it'll be pretty evident about the need for this. That said, there's an importance in belt and suspendering it with further legislation, just to make it abundantly clear to future Department of Justice or other state agencies that donor information should be private, and without the need for any to go through 7 years of litigation like Americans for Prosperity Foundation did. So we think that's important. And frankly, we think there are 3 reasons for passing it. Again, this isn't about us. It's about protecting the smaller nonprofits who frankly might not have the resources to go and litigate out a case like this. I think that codifying it into the statute makes it more clear to future departments of justice and other state agencies that donor privacy is going to be protected here in New Hampshire. I think that beyond that, I think that what this does also is giving a cause of action. It obviously further makes abundantly clear to any public entities about the importance and how serious the legislature takes this matter. I think that's critical as well. And then finally, we think that this particular legislation is important because it also helps start to build a foundation around the 2018 constitutional amendment, the right to privacy, which says pretty clearly an individual's right to live free from governmental intrusion in private or personal information is natural, essential, and inherent. And although that is a great and very broad constitutional amendment, as we know, there's not really a whole lot of case law surrounding that would support what that constitutional amendment actually means. So we think that bills like this begin the process of actually building a firewall around that and giving a statutory foundation to what it is. And there are other pieces of legislation I know coming over from the House that will continue to do that. And for that reason, again, we weren't involved in the development, so there may be some rough patches and there might be some amending necessary, but believe that conceptually this is an important step forward as far as protecting the privacy rights for nonprofits and their donors. I'd be happy to take any questions.
Thank you very much for your testimony, Mr. Moore. Are there any questions from the committee? Okay, seeing none. Senator Khan.
Thanks. Do you recognize the point that was made by the Department of Justice staff relative to the need for directors and information?
Again, as a member of boards myself, I certainly realize that going in and serving on a board of director that's part of the deal. And I don't necessarily think that boards of directors themselves need to be shielded from public disclosure. The focus here should be on the donors and not the boards. I'd be careful about the size of the exemption you put in there because attorneys general have the ability to be pretty creative about what they can use an exemption for. So I think that I would think that making sure that you narrowly tailor any exemptions as far as accessing donor information is something that I would consider very, very significantly as far as how you tailor that. And I know it's a fine path to walk, but it's a narrow path, but I think it's possible to be done.
Are there any further questions for Mr. Moore? Okay, seeing none, thank you very much for your
Thank you.
testimony. Next, we're going to call Mary Ann Dempsey. Good afternoon, Ms. Dempsey.
Good afternoon, Senators. For the record, my name is Mary Ann Dempsey. I'm General Counsel for the New Hampshire Judicial Branch. I'm here to provide comment on a very specific portion of the bill. So bear with me. It is Roman numeral 3, Section E, and that is essentially what happens when that information is involved in a court case. It provides that the court cannot release the information absent a specific finding of good cause. We at the Judicial Branch have proposed some language that I will share with the committee, but it's just to make clear how confidential information is provided to the court, both in pleadings and in testimony. And what I mean by that is it's the party who is submitting the information, who files the information under a motion to seal, and advises the court that there is confidential information coming to the court. Similarly, if there were to be a hearing where confidential information was going to be discussed, the attorney or the party would let the court know that, and so then the court was able to take opportunities to close the courtroom and hear the testimony in a confidential manner. So we would just respectfully, we have suggested some language that makes clear that if a party is planning to provide this information to the court, it be done via a motion to seal, and similarly, if they were to discuss the matter in court, that they would take the proper measures to keep the information confidential. So with the committee's indulgence, I'll provide copies of just our proposed language, but it's on that specific part of the bill.
Thank you very much for your testimony. Are there any questions from the committee? Okay. Seeing none, please hand the testimony to Jen. Thank you.
Thank you for your time.
Next, we're going to call Kathleen Reardon. Good afternoon, Ms. Reardon.
Good afternoon, Madam Chair and committee. Thank you for allowing me to speak here. My name is Kathleen Reardon. I'm the CEO of the New Hampshire Center for Nonprofits, a nonprofit membership organization that strengthens and gives voice to nonprofit nonprofits. We have over 700 members. And we certainly appreciate the bill sponsors' interest in supporting, but are here to express our concerns about some unintended consequences of the legislation. First of all, it's so important that we preserve the public's trust in New Hampshire's nonprofits. We in New Hampshire nonprofit sector extensively, and we've seen all sorts of challenges. It's clear that nonprofits not only provide essential service to communities, so the public relies upon us to manage our position to deal politically nonpartisan. Any kinds of records for public trust in nonprofits. And we do value as nonprofits are private organizations that result of regulations be more effective. And to me, it's important to these organizations is that we are in and we are one of the places that we are. And so we encourage we support that five organizations. Main transparency, we're concerned hampering public agents as proposed in SB 302. We attempt to make the organization noted by Tom and others that charitable American prosperity. So that donor privacy or so we really feel this is necessary. Thank you.
Thank you very much for your testimony. Are there any questions for Ms. Martin? Seeing none, thank you very much for your testimony. The chair will call Elizabeth McGlynn. I hope I didn't put your name on. We try to be polite here.
Well, I appreciate it. Thank you, Chairman Carson and members of the committee for having here today. My name is Elizabeth Wiggin. I'd like to testify in support of 302. I am the Director of Policy for the Philanthropy Roundtable. So the Roundtable members include individual givers, family foundations, and community foundations located in New Hampshire and around the country. We think SB 302 would help to strengthen the vitality and the breadth of society in New Hampshire. With regard to the concerns raised by the Department of Justice Office today, we would be open to working together on a narrow amendment to address their concerns. We feel the exemptions outlined within the bill for cases, warrants, investigations, in cases where there's evidence of a need for this information. That's the goal of the bill. We all share the goal of ensuring regulatory oversight may be maintained, and that in turn will help protect the public's trust in charitable organizations. What I'd like to speak to today is more of the reason behind this bill, why it is so important, even with the possible addition of additional. So throughout our nation's history, the norm has been that people are choose for themselves what be public or private in their charitable giving, and only in very narrow circumstances, as you see in this bill for parties and candidates made this long-standing noise aside. So now, in a time of deviation with the rise of so-called cancel culture, the choice to remain honest, charitable giving, and association is really crucial. Donors to charitable organizations may have concerns that they have causes, whether they're controversial now or may become controversial in the future, might trigger retaliation. So Parkhouse already gone through the NAACP versus Alabama and the AFP vaunted cases. However, it's not just the fear of harassment, retaliation that leads donors to want to remain anonymous. Anonymous Judiciary goes back at least 2 millennia and has important religious, cultural, moral roots. Many donors want to avoid solicitations through their gifts. Others want to keep the focus on the good work that the charities are doing. Not really the goal of this bill. And I would say also New Hampshire's citizens and residents are no strangers to anonymous giving. For example, in New Hampshire, an anonymous private foundation matched donations up to $100,000 for the New Hampshire Food Bank, and what kind of gift for this organization. In 2017, the food bank received an anonymous $1 million donation, which included funds for the organization's culinary job training program, mobile food pantries, and to reduce costs for 430 partner agencies. Elsewhere, in 2019, New England College and Head recipient of a $5 million anonymous donation to pay for a new athletic center on the college campus. Why givers choose to remain private, but we do know that communities throughout the state have benefited from their unheralded generosity. The last thing we want to do is chill these types of gifts. Now, with regard to concerns raised about the politicization, of countries, I would point to the fact that the bill does allow for the proper regulation of campaign finance, political contributions, lobbying, spending. All of these sorts of issues should be transparent and would remain transparent within this bill. What SB 302 would do is protect this long-standing and vital norm of allowing donors to organizations to remain private. Without the protections of this measure, charitable organizations would be at the risk of having to violate the privacy of their donors. Forced disclosure for the organization, many who prefer to remain out of the public eye for a variety point I would like to raise up during the Department of Justice testimony is that I think it's important to note that the issue of public disclosure versus disclosure of the government body did come up during the Americans for Prosperity Foundation case. This was brought up by the defendants, and the Supreme Court did find that it was insufficient to claim that the information provided to the government would not be disclosed publicly. They found that it would still have the chilling effect of getting in freedom of association, regardless of what information is expected to be made public or not. So, wrap up. SB 302 would protect the right to give privately, and I applaud the committee for considering it. I'm happy to respond to any questions you may have.
Thank you very much for your testimony this afternoon. Are there any questions from the committee? Seeing none, thank you very much. Next, we're going to Margaret
Good afternoon, members. My name is Margaret Burns. I'm the Executive Director of the New Hampshire Municipal Association. We are not opposing the bill, but we do have some concerns with the language in the bill. The first concern is that based on the testimony I've heard this afternoon, the bill seems to deal with an issue at the state level. So with the information that the state is requiring or gathering from nonprofits. However, the language of this bill also applies to municipalities as well. And the concern there is that assuming municipalities have this kind of information, which I'm not sure that they do, but in some circumstances they do have this sort of information, even an inadvertent disclosure of this type of information to a potential liability for municipalities under the final section of the bill. The second concern with Senate Bill 302 is that it's a prohibition on the release of certain information. And the language would be inserted into RS Chapter 91A, the right to know law. The right to know law really deals with information that is public and the information that is disclosure either by the state or municipalities. It doesn't deal with bans or prohibitions on the release of certain information. So should the Privacy Act or legislation like this go into law, I would suggest that it be more appropriately placed in a different section or in its own act rather than appended to the right to know law. The final concern already referenced is that it does create new liability, new civil damages, and a new cause of action against governments, including municipalities. And so that provision of the bill we would specifically oppose. I'm happy to take any questions.
Thank you for your testimony this morning, this afternoon, Ms. Burns. Are there any questions? Okay. Seeing none, thank you. Are there any other member of the public who would like to speak to Senate Bill 302? Seeing none, we're going to close the public hearing. Senate Bill 302.
I have a 220 I have to present. So, your is Senator Tom Sherman, District 24. And I have to introduce another bill in 3 minutes, so I'll make this super brief. This bill was first brought forward, I believe it was in 2020, and then it was a victim of COVID. A constituent who sits behind me, Chelsea, brought this concern. We have Chelsea Christensen brought the concern. It is now commonplace, as many of us know, for adults to cohabitate without marriage, and some of them go into a fairly deep level of relationship. They may stay together for years, they may raise children, buy houses, but never get married. Some states have created prenups without the nup. In other words, they've created a mechanism to recognize these relationships. And many couples are essentially functioning as a married couple without legal protections married couples have. So Chelsea will tell her story. When I started looking into this, trying to design a solution, I realized this is such an incredibly complex issue that a study committee would be probably the most appropriate way to address it, so that we could figure out if something needs to be done, what needs to be done, and what is best for the state of New Hampshire legislation-wise. So that's what you have in front of you, is a committee to study the issue of unmarried cohabitants. And you'll see the charge, and I hope you'll agree with me that this is worth looking at with the study committee. I'm happy to take any questions.
Thank you very much for your testimony, Senator. Are there any questions from the committee? Senator Whitley.
Well, I'll let Chelsea tell her story, but the concern is splitting the assets, but also making sure there is adequate protection you know, there is there are provisions for how uh, children that are a result of that union are protected and supported, but that's essentially it in my understanding. And beyond that, right now, there's very little protection for people involved in that level of relationship. So the question is, should there be? And there should, if there should be, what should this protection be?
Yes.
That's where it got complicated. That was clearly out of my league when I started looking at this, and that's why it's in front of you, and that's why I'm proposing a committee than rather than my trying to work through this on my own. It's very, very complicated reviewing case. I did have some research look into it, especially trying to look at what is going on in other states, and there are many different solutions to the issue. So that's where we landed.
Yeah, I asked because the common law, common marriage has been a sort of established in our
I think Chelsea's story will be really helpful in understanding this.
Senator Collins' question.
I'll be quick. We have family courts and case law. You've got a committee. You had to consider, and you don't answer that. It's just if that's something that might flush this out faster and more thoroughly.
I did consider a commission. It seemed like a committee might be a little bit, might move a little bit more quickly. But a commission, I would be certainly open to the idea of commission versus a committee on it. I think from the work I did to try to understand it better as I said, it's very complex, and trying to understand what other states have done, what we are as a state, and being able to end up doing the right thing. The idea for me of a Senate committee or a Senate-based committee was one that I thought would bring as many experts together as needed, but also answer the question a little more quickly. And obviously with COVID, we're now a year later, or 2 years later at this point. So it's so quickly isn't necessarily as important as doing it right. So I'd be certainly to a commission if you all felt that was more appropriate.
Thank you. Are there any further questions?
All right,
Seeing nothing, Representative.
Untitled over to.
Next, we will call Chelsea Christensen. Good afternoon, Ms. Christensen.
Thank you for hearing this case. I feel this is really important. And I'm speaking in my situation based on this is more of a sort of traditional domestic situation, but there are other types of dynamic relationships to consider, same sex, that kind of thing. In my situation, I was with my significant years. We cohabitated, raised 2 children together, bought a home together. At the end of this relationship, through the relationship, obviously more traditional sense in that, I was helping raise the children. I was helping him with his career while he tries to work. He makes a lot of money, so he's on demand and always traveling. So I was able to help him through that process. Obviously, he's building his retirement plan. He's building all these things that I'm helping support. When leaving a relationship, of course, there was, people end relationships because it's spiteful. Through that process, I found out that I really don't have a lot of protections. There's a huge disparity in the amount of money that he makes and the amount of money that he was able to save with his retirement, things like that. I did not have access to. I did not get alimony. The only thing that I have access to is child support. We've been apart now for 3 years. He subsequently had canceled my health care, which I had through domestic partnership with him. It was a domestic care plan that was very affordable. It was, you know, $100 and something dollars. Then he fully canceled that. There's no repercussions for that, no protections on that. Obviously, I didn't get alimony or any of his retirement helped him build. The disparity in income, yes, I do get, you know, a decent amount in child support. The Coder versus Coder law is that if one party is the other full child support, the other person receiving the child support cannot go and ask for more for, let's say, extracurricular activities, things like that, which I understand. But because the amount that he is giving me in child support, I obviously want best for my children. I spend a lot of money in their activities. They're in ski lessons, ballet, gymnastics, and I want that for them. That basically takes up all the child support. We've been apart now for 3 years. Through those years, I was just recently able to build a home, which was, you know, the most affordable route versus buying. Building I was able to do. But leading up to those 3 years, I've lived in apartments that we shared. You know, I lived in a fifth world camper for a while. It's just the disparity with, you know, he makes 3 times what I make. He, you know, has multiple cars, a nice big house, a ski condo, things like that. So the laws are very disparaging in that way. Divorce laws were set up so that when you do build a life together, you both benefit from that life you've built together, and that it's more equal for the children to have an equal lifestyle or whatever with both parents. So when they were with him, it was one way. When they were with me, it was, you know, living in a one bedroom apartment, so on and so forth. So the financial aspect was very difficult, and I feel that if there were laws in place that recognized that for 10 years building this life together, we could be treated the same way you would as a married couple. That's why these divorce laws are put in place, is, you know, to protect both parties. And I feel that there's a disparity. You mentioned common law marriage. I believe that was adopted a number of years ago. It was something that I believe was put into place after 7 years of the relationship, and then I believe that law is now dissolved because, of course, through this process of splitting up, I have looked into different things, and I wasn't able to get common law marriage or any of that stuff. So I don't know if that gives you enough background on kind of what I've been dealing with. But I actually feel I was pretty lucky in that I was able to finally build a home and things like that. I feel that there are other people out there that, you know, whether it's same-sex marriages or maybe another more traditional relationship, that maybe someone's not as fortunate as I to be able to finally get back on their feet and be able to afford the things that I can afford in situations I would like to see a law put into place to protect other people that might not be in my situation, that might have a worse situation. Because of the Code Air versus Code Air, it makes it very difficult to go forward and ask for more support with helping with extracurricular activities. The child support is only supposed to be for those things, so I can't go back and ask for his help. He doesn't want to split, of course he's very spiteful, so he doesn't want to split anything with me, so that becomes very challenging. So I don't know if that helps you an overview on my opinion.
Thank you very much for your testimony. Yes, it does. Are there any questions from the committee? Okay. I have a question about visitation. Sure. Did you have to go through court process to accept visitation?
Yes, I mean, we've been through family court. Unfortunately, I'm still dealing with it. But he and I we were amicable in deciding how the children would be, I guess, visited or separated. But we have a 50-50. We never disputed with each other. If there had been a dispute, I don't really know what that would have looked like, because luckily we were in agreement on that. But we do have 50-50 care of the children.
Okay, and you've quoted a case, Code Air versus Code Air?
That's my understanding. I hadn't looked at the bill myself, but that's my understanding. In New Hampshire, it was established that if one party pays full child support and the other party cannot go back and ask for funds to support, like extra activities. Like, for example, I put my children in ski lessons and I buy their ski passes. I could ask, he could say, sure, I'm willing to split that, but he does not have to. So that's kind of the law there, is that once I get the full child support, I can't ask for anything additional. That's my understanding of the law. I may have misinterpreted, but that's the way my attorney explained it to me.
Okay, thank you. Mr. Lehman, could you make sure that the committee gets a copy of that? Thank you. Are there any questions for Ms. Christensen? Senator Khan.
Thanks, Madam Chair. So you did access family court.
Yes.
And it obviously must have helped you in determining child support and custody.
Yes.
And what was the limitation in family court that you experienced relative? I mean, it sounds like there were certain kinds of issues you wish would have been resolved in the family court that weren't.
Right.
And I'm like a little bit of a sense of, so where did the court hold up? Why are they a little short on issues of care?
Yeah, healthcare was a big
alimony.
That was a big problem. Is that I had no control over that.
John, testing 1 2 3, testing 1 2 3. Testing 1 2 3, testing 1 2 3. Testing 1 2 2, testing 1 2.
The committee will come out of recess. I would just like to remind everyone our executive sessions are also online and being streamed. So we had a number of bills today. I think they were all very important bills, but I think for the most part, they need some, I do not believe anything's ready for us to exec today. So we are not going to exec any bills this afternoon. So that being said, can I get a motion to adjourn? Moved by Senator French, seconded by Senator Whitley. All in favor say aye. Aye. Any opposed? Okay. The committee will be adjourned.